with Hardworking Mom, and welcome to Thursday Business Tip. So, I see this all the time, and I thought it would be a really great thing to do a tip about. So, I'm going to do a tip about trademarks and copyrights because there seems to be tons of confusion, especially in the craft industry, about what is copyright protected, what is a trademark, what can you do, what can't you do. So I thought it'd be a great idea to do a tip on this. So let's talk about this. Okay, first let's talk about trademarks. Okay, so this right here. So this is a little football, okay, and it has the symbol for Carolina. Okay, so this is the Gamecock. This is a trademarked item. So what that means is that the university actually has a trademark on this symbol and the wording, the colors, so on and so forth. So if you use this on a wreath, if you use it on a craft, if you put it on a sign, yes, you better not sell it, okay? Because if you sell it, you have just violated their trademark. And guess what? They can sue you. And just because you might have sold something in the past and it was fine doesn't mean that you won't get caught this time. So this is a pretty simple example. Let's talk about Disney, okay? Even things like the Grinch, Mickey and Minnie Mouse, those are all copyrighted. And Disney takes their trademarks extremely serious. So that means if you do a wreath and you use the little ears and the round, you have violated their trademark. Even if you don't have a Disney character in there, if you reproduce it in any way and you can tell what it is, guess what? That's a trademark violation. So here's my advice, okay? Don't sell it. Don't sell it with anything that could be considered a violation of their trademark, because you can get fined heavily, and I do mean heavily. So let's talk about what you can do. Okay, you can still do it. You can still do a wreath with any of these items if you're making it for yourself, if you're giving it as a gift. Absolutely. You can do it. You're not violating their trademark. You've purchased it from someone who has purchased a license in order to sell these. So Craft Outlet, Sims Pottery, Carolina Pottery, a lot of these stores have purchased licenses in order to sell these products. So in order to sell this, I would have to go to the University of South Carolina and get a license. If I wanted to sell something that was Disney, I would have to approach Disney and I would have to get a license. And I can tell you those are really expensive, even for college football. So what can you do to get around that? So let's talk about this. You see this? So this is just an ornament that has red and black on it. I can use this in a wreath, and I can make it Georgia themed, but I can't say Georgia football wreath, okay? Because if I say Georgia football wreath, guess what? Yeah, I violated the trademark. But if I say red and black football wreath, I'm fine. So you just have to be very careful. So you can find things. Okay, so like I could use this for Alabama. I could use it for South Carolina. As long as I don't say in the title that that's what I'm doing, as long as I just say, I could even say crimson and white football wreath. Okay, so people who like those teams can buy this and then they can add something to it and make it their own. You could sell a wreath that has all of the colors in it because their trademark is very, very specific to colors. And when you buy things like this, this is a generic color. Okay. So you see this is a very specific color. This is a generic color. So you can tell, right, that it is slightly different. So that's perfectly fine. You can do that. Look here. So you see these are Tennessee colors, but there's nothing on here that is trademarked for Tennessee. Okay? So it's fine to use this. It's even fine to use this. Because it is not specifically the trademarked item, it's fine to use something generic like this. Okay, so that covers trademarks. And just so you know, if you get a logo and you don't want anyone to ever be able to use that logo again, you can apply for a trademark yourself. Okay, it's very specific, very, very specific. It has to be an original piece of art. You have to own 100% of the rights to it. And, you know, they're very specific about the colors, you know, the text, what's in it. It can even be the font of the text. But you can apply for them. You don't really need a lawyer to do it. You just go out on the website for trademarks and you can apply for it right online. You can apply for copyrights online as well, which is the next subject. Okay, so let's talk about copyright. So copyright laws protect original pieces of art, illustration, literature. So a song can be copyrighted, a book can be copyrighted, things like that. What does it not protect? It does not protect a method. Methods are not protected under copyright laws. You can look this up on copyright.org, and it is very specific what it says. A method is not copyrightable, okay? So let's take, for example, Unique in the Creek. So they have a patented way that they do their flowers, and there is a board that comes with that. And that is copyrighted because of the patented board. But you could get the board and do something else with it that is not exactly what they did, and then it falls outside of the copyright. So you have to be very careful when you are working with things that are copyrighted. Okay, let's talk about zip ties. Okay, so you can't copyright, you can't use zip ties in your craft and say it's copyrighted, because guess what? This is a general purpose item, and if a patent is held, it's held by the company that owns these zip ties and not everyday craft people. This, okay? So there would be a patent on this, which means you cannot copy this design. However, if you use it in your craft for its intended purpose, even if you use it for something that's outside its intended purpose, not copyrightable that you actually use this piece of equipment. Okay, so that would be considered a method, actually using this to cut your mesh, your fabric, because that's its intended use. It is a, usually these are like utility patents, okay? So anybody who uses this, you know, they're not violating that copyright because that's its intended use. Okay, so you cannot go out and use this and say, you can't use this method to do your wreaths because I've done it before. Because guess what? The only person that holds the patent and the copyright to this is this company right here. Okay, we don't own the rights to that. They do. So we can't go out and say you can't do it this way, because that is considered to be a method. All right, so let's talk about a wreath or a sign or something else. If you designed it, absolutely, that can be copyrighted, but this is the very specific thing about it. It would have to be exactly the same down to the last thing used in order for a copyright to protect it. So if you bought a SVG file off of Etsy and it says from the designer who made it, you can use it up to 50 times, and you do 51, guess what? You just violated your license right. So you have to be very careful, but you don't need to worry about doing something like if you see someone do a wreath and they use the poof method, then absolutely you can go out and use the poof method, because guess what? It's a method. That's not protected. If you see someone use a bunch of zip ties doing something, that's not protected. That's a method. If you try to copy exactly what that person did, then yes, absolutely, you're violating the copyright, because those laws are there to protect designs, illustrations, original works of art. So if you make a wreath, that is your original work of art. But I'm going to tell you, if somebody else goes and makes one just like it, the chances of them getting it exactly the same are pretty much impossible. Okay? So, you know, I don't want you to think that you can't use other people's methods that you've seen them use. Just be very careful that you don't use a patented method. Okay, so if you, like we talked about the board, so Unique in the Creek has a patent on her board, and so if you got the board and you used that board to make exactly the same one that she has patented, you violated it. If you buy the board and you do something else with it, you haven't violated it. You couldn't copy the board and sell it, because that would be a violation. So you see how this works. Just be really careful. Don't use trademarked or copyrighted items in your work, because you will get in trouble. Don't use those tags on Etsy. If you are selling your items that you've made on Etsy, if you put it in your tags, guess what? You've just violated that trademarked item and their copyright. So you don't want to do that. You just be generic, okay? Don't get yourself in trouble. If you really want to be able to sell it, then by all means, you contact each individual company, such as Disney or a college, to buy the license rights. And you have to buy them for a year, and then next year comes around and you're going to have to buy it again. Okay, and it can be really expensive. It can be thousands of dollars. So, you know, they're lending out the right for people to use their license, and they're getting thousands of dollars for that. Absolutely, they're going to protect it. Okay, so they have people who are scouring Facebook and YouTube and things like that, and they're looking for people who are using their trademarked items and then making a profit on it. So don't do that. So, you know, when I've made things, like I've made things with Disney, I gave that to my brother, because, you know, you don't want to mess with something that is trademarked or copyrighted. There are protections for a reason for those people. But just remember, you can't copyright a method unless it is something that is very specific, that is covered by a patent, like a design patent, okay? So let's talk just a little bit more specifically about the example that we talked about with Unique in the Creek. So if you purchase the board and you purchase the tutorial and you did it, you can certainly sell the wreath. However, if you purchase the board and you purchase the tutorial and you share it or show someone else how to do that, you have violated that patent. You've violated their copyright, and absolutely she would have every right to go and sue you, and that just wouldn't be good. Okay, so yes, it is almost impossible for you to copy exactly what someone else did. It's not really violating the law if you do that. However, you know, you need to have professional courtesy. So if you see someone else make something and it's very popular. So let's talk about the person who did the pineapple wreath last year. All of us went and did a pineapple wreath that was like hers, and you know, it's professional courtesy to not try to copy what someone does exactly, because I mean, you know, if you made something that was unique and it was great and it became a great seller, you wouldn't want everyone else to go around and copy exactly what you did, because even if they're not violating your copyright, you know, professionally, it's not really great. So I know when I did mine, I made it different. I made it mine, and that's fine. You know, yes, you're taking inspiration from what they did, but you make yours different. Okay, so that's just common professional courtesy to do that. And that would be my suggestion. If you see something that you absolutely love, it doesn't mean that you can't go and make one like it, but you need to remember that you need to make it your own. You need to make it different because you want to respect that person and respect their creation. Okay? So I'm sure this will bring up some questions for you. So make sure to put them in the comments and I will come back and answer. And I will be doing another tip next week, and I think next week will be on inventory. All right, so have a wonderful day, and I will see you next Thursday. Bye-bye.